Well, good evening, everyone. It's our honor to have you join us tonight to launch our Mansfield Dialogue series. Tonight, we are starting off with the legacy of Justice Ruth Bader Ginsburg. I'm honored to introduce our moderator for this evening, Anthony Johnstone. He is the Helen and David Mason Professor of Law and an affiliated professor of public administration at the University of Montana, Blewett School of Law. He teaches and writes about federal and state constitutional law, legislation, election law, jurisprudence, and related subjects. Before joining the School of Law, Professor Johnstone served as the solicitor for the state of Montana, practiced litigation as an associate at Cravath, Swain & Moore in New York, and clerked for the Honorable Sidney R. Thomas, United States Court of Appeals for the Ninth Circuit. He holds a BA from Yale University and a JD with honors from the University of Chicago Law School. So Anthony, thank you so much for leading us tonight in this discussion.
Thank you, Dina, and good evening to everyone, and thanks to the Mansfield Center. It's an honor to kick off this year's Mansfield Dialogues. It's a blockbuster lineup. They really highlight the breadth and depth of the University of Montana's community of excellence in justice, policy, and public service. So it's so good to see so many of our colleagues lined up for interesting discussions throughout this fall. And it is my privilege to introduce Professor Elizabeth Porter. Liz Porter is the Charles I. Stone Professor of Law and Associate Dean for Academic Administration at the University of Washington School of Law. Her research, which has been published in top journals, focuses on civil litigation. She is an acclaimed teacher as well, and in the classroom emphasizes both theory and development of practical skills, especially legal writing. I am personally grateful to Liz for her influential scholarship on the role of the Socratic method in an active learning classroom environment. Professor Porter came to teaching from commercial litigation practice at Jenner Block in Washington, D.C. She has a JD from Columbia Law School, where she was a James Kent Scholar, a Harlan Fiske Stone Scholar, and an articles editor for the Columbia Law Review. She also has a BA magna cum laude from Brown University and a master's in education from the Harvard Graduate School of Education. Following law school, Professor Porter served as a law clerk for Judge Sidney R. Thomas at the United States Ninth Circuit Court of Appeals right here in Montana. During October term 2002, she was a law clerk for Justice Ruth Bader Ginsburg at the United States Supreme Court. We have so much we could talk about, but tonight we'll focus on this last item, your opportunity to spend a formative year in the chambers of the late Justice Ginsburg. Welcome, Liz.
Thank you, Anthony.
So let's start. And I'll mention we'll leave some time for questions at the end. Save your questions, but when we get to the appropriate time, you'll be able to put them in the chat box, and we're also keeping an eye on questions on Facebook, and we'll be happy to address those when we wrap up our initial presentation. How did you first meet Justice Ginsburg?
Well, her chambers called me to invite me for an interview, which felt at the time like being struck by lightning. I was so shocked. I was living in Billings. I was clerking for Judge Thomas at the time. And because you're all Montanans, and I assume some of you know Judge Thomas, I can tell you all that, first of all, I was terrified of Judge Thomas because I didn't know very much. I was just a new lawyer, but I knew enough to know that I knew a lot less than him about pretty much everything, not only the law, but sports, films, music, pretty much everything. But I went to Judge Thomas's chambers. I knocked on his doors and I said, Justice Ginsburg's chambers just called to offer me an interview. And he looked up and he said, oh, well, I thought that might happen. And I said, it was the first moment where I was willing to say something to the judge that was not proper. I said, okay, that's not going to be enough for me here. I'm going to go back outside. I'm going to knock on this door again. I'm going to come in. I'm going to give you that news again. And I need you to react. And the second time I went in, he jumped up and down and made a fool of himself, which was great. So I still don't really know why it was me, except that the justice chooses her clerks for interviews by having her husband, Marty, read student writing samples. And I was a complete nerd about civil procedure, starting the very beginning of law school. I was a TA for civil procedure in law school. And I think I'd written a really arcane paper on like, sorry to even say these words out loud, but it was probably on like non-mutual collateral estoppel in class actions or something. So maybe that's why I'm here.
What was the interview like?
So I'm not usually actually terrified, but the interview was terrifying. First of all, it just felt kind of surreal I had to leave a day early to make sure I could get there because it was December. So it was already pretty snowy in Montana and throughout the Midwest. So it felt like kind of like this journey to the city that I didn't know very well. The Supreme Court is obviously huge. And I also felt like I really shouldn't blow it in a way that I hadn't felt about other interviews in my life. But I think for the justice, I was a completely straightforward transaction. I think I walked in, the court was deciding Bush versus Gore. They had serious things on their mind, and I was not one of those serious things. So first, actually, you wait in the waiting room and talk to the clerks before you're waiting to go to talk to the justice. And the clerks must realize that the people who are interviewing are very, very nervous because they asked me, I still remember they asked me these really, really easy questions like, so Montana, is it cold there? And then I think when I walked in to talk to Justice Ginsburg, I think she probably looked up, looked at me and thought, this woman will do. And then she probably thought, how long does this interview need to go on so that it will be worth it for this woman to have flown here from Montana? And the answer is really about 22 minutes. So it wasn't an incredibly substantive interview. She did tell me during the interview that she had had cancer, which of course I knew because it was public information that she had colon cancer. And I told her that I had a child, that I'd had a baby in law school, which actually I think she liked, which she had not known before, but I felt like I should disclose prior to my clerkship. We talked a little bit about travel. I feel like we talked about Japan, and that was it. She presumably went on to the next part of her day. She offered me the job on the spot.
All while they were busy deciding a presidential election and everything else.
Right, you don't want to have to answer a question about that.
So you didn't. Good. So you got the job.
I'm still surprised.
So what is a day in the life of Ginsburg clerk in the chambers? I guess we should first say that a lot of people might not know what law clerks do. Kind of they're the kind of legal research assistants for judges, and usually they just rotate through a chambers. Each judge has 3 or 4 of them or so. And they help the judge research and analyze the issues and bounce questions off of them, maybe draft some opinions. But what was it like with Justice Ginsburg?
Yeah, it actually varies quite a bit by chambers. So some judges, and this was not Justice Ginsburg, wanted to talk over the cases with their law clerks, right? Walk around the court maybe and have a kind of discussion about it, but then the judges would do the writing themselves. Justice Ginsburg really preferred us to write things down, which very much suited me. She had a more formal way of doing things because I think she made it more, she felt that it created a more precise work product. And I agree with that. At the same time, we were allowed to keep whichever hours we wanted to keep, and there was no dress code. So some of the other chambers, everybody had to be wearing a suit every day. And in Justice Ginsburg's chambers, I really think she didn't care. And actually, I kind of posit now that the reason that she didn't care is that she's incredibly stylish, and maybe there was just nothing we could have done to make it what she considered to be high style. So we could come in when we wanted, we could leave when we wanted. Because I had a baby, my son turned 3 while I was clerking. I kept very regular hours. I dropped my son at daycare. I was in at 8, and then I was typically running out of there to pick up my son at daycare. My husband was working on the Hill, and he was also going to school part-time that year. So it wasn't our most relaxed year. The justice herself is famously a night owl. So she might not arrive until shortly before at work. Sometimes if we weren't hearing cases, she might not get into the office until shortly before I was leaving. But it didn't really matter because we could communicate at that time. We didn't really communicate by email. We didn't even have external email. We had to go to we'd use a different computer to email externally for security reasons, but we could communicate simply by our internal email or in writing, and it worked just fine.
So how does an assignment begin for Justice Ginsburg? How does she give you an assignment? What does it look like? And what's the process she'll go through in working up a case for say, an opinion?
Well, so we actually have two kind of different responsibilities in the court. Justice Ginsburg was part of the cert pool. So that was all of the justices except Justice Stevens while I was there. So all the law clerks who are part of the cert pool help the court screen cases to either grant or deny. So one of the things that I had to do, that we all had to do in those 8 chambers, was review, I don't know, 4 to 8 petitions every week or 2, and just try to write a memo to the full court, not only to Justice Ginsburg, but to the full court, recommending whether the court should grant review of that case. And it was really important to me, and I think important to the court, that we took that role seriously as being not advocating for our own justice in particular, but rather saying this is a good vehicle. This is an important case. There's a conflict among the circuits. This is an appropriate case for resolution. There are no jurisdictional problems. So that's one part of being a clerk. And actually, I have to say, I really enjoyed it. It's really an honor to see all the different legal issues that are percolating up through the country, and just have a chance to kind of see what the country is thinking about on a legal basis. And it's also somewhat satisfying to write those very short, compact memos to all the justices, kind of getting to the essence of things. And then for the justice, we got to choose our own cases among the 4 of us, the 4 clerks. So we could choose, I was number 3. So 1, 2, 3, 4, 4, 3, 2, 1 of the 8 cases of a term. And then the next term I would be number 2 and I would be number 1. So we sort of had some horse trading in our back chambers as to who got which cases. And for each case, you would write a bench memo. And then if the justice wrote a decision that came out of that, and that your case was assigned to the justice, you would help the justice write her majority opinion, her concurrence, or her dissent.
And I mean, we should say the reason for the cert pool is because the court gets about 8,000 petitions a year. Correct. And it only hears, at that time, 80 or 90, nowadays 70, although that might start going up again. Chief Justice Roberts, when under his confirmation hearing, suggested that he thought the court should hear more cases, basically that the taxpayers are paying for the court and there should be more. But the sort of guidelines of what types of cases the courts should hear are fairly narrow. And I think actually with our increasing reliance on electronic databases, probably some of the cases that the court used to hear, which were just inconsistencies, have just been ironed out on their own because you have sort of better access to see what the other courts are doing. Yeah. So, you got the job in part based on the writing. How did it work back and forth, writing with her, for her, comments back, and what did that look like?
Well, first of all, she would always say, when you write me a bench memo, you don't have to reach the conclusion that I would reach necessarily. And I'm just saying, I never fully believed that. I always felt like she would think my bench memo was better written if she also happened to agree with its conclusion. But how could I know all the time, right? Sometimes you would know, you would see precedent, you would know what the justice thinks. And sometimes, you have to just use your best judgment.
Yeah, law professors have no idea what you're talking about, right?
The key thing for her was to basically draw all the lines of the argument so that, for example, if you couldn't read the briefs, you could read the memo and you could simply understand what was happening. For an opinion or a dissent, it's a bit trickier because really different judges do it differently all over the country, but you can tell from reading Justice Ginsburg's opinion that every word that is written has come from her. It's all her voice. She has a very distinctive voice in writing. She is very concise in the way she talks. Also in the way she talks and the way she writes. She doesn't have any extraneous language. If you look at her legal opinions, the writing is almost like poetry, actually. And I don't mean poetry in the florid sense. I mean poetry in the sense that she's getting the most out of every word. So if you're doing writing that was going to be part of an opinion, you really tried your best to jump into Justice Ginsburg's voice. As a separate matter, one of the things that's interesting for me about working with Justice Ginsburg is that I speak very quickly, and Justice Ginsburg does not, because she doesn't use she pauses and she thinks about her dependent clauses before she says them. So if you think about it as a deposition transcript, it's always completely clean, but that means that sometimes there are pauses in a mid-sentence. And I just had to get used to the fact that I was going, you know, I was probably much less precise and much faster. And so working in writing was actually easier for me because in writing we were more similar.
Well, so she was not only your boss for this year, she was also your mentor. What other lessons of both substance and style did you learn working with her?
One of the things I admired about the justice was that she enjoyed her life. She worked very hard, but she loved her work, but she did work very hard. And sometimes I think she had to be reminded to come home, get some sleep, eat some food. But she had, you know, she lived right near the opera. She went to the opera on a regular basis. As everyone knows, she totally loved the opera, but she also loved art, and she had a wide social circle, and she just seemed to enjoy, I don't know, everyday life. And I think that that's really important when you have a highly stressful job. She was very, very, her opinions would really represent her best work and her true voice. That really mattered to her. It's not that it wasn't stressful, but I think she in some ways wore it lightly, wore that responsibility lightly in the rest of her life. And I have tried, but not always succeeded in doing that. In another realm, however, I have followed her precisely, and it's totally worked out for me. She was married to a tax lawyer, and so am I, and I totally recommend that, actually.
I know I have a couple of colleagues I know who heartily endorse that thoughts.
It's really worked out. They turned out to be very good cooks, apparently, and just lovely people.
When did you last have a chance to see her?
I saw her in 2018. There was a celebration for her 25 years on the bench at the court. And then I was on sabbatical. I went off to Berlin for a year, and I came back, and, you know, I haven't traveled because of the pandemic. So it's been hard to hear over, you know, from so far away that she's been ill, and hard to think of her as feeling really obligated to keep working despite the fact that she was struggling with this illness. Although she really loved her work, so I don't really know if she would have chosen to put it down.
Mm-hmm. We'll talk a little bit more about the human element of the court and the dynamic between the justices, but I thought I'd note, I'd shared this with you. I was at the court in January for a case, and Justice Ginsburg was quite frail, and Justice Thomas, sitting next, helped her off of the bench, which was surprising because she was as fierce as ever in the argument itself, in her quiet, concise way, with excellent questions. Well, why don't we turn now to a little bit of you know, so many of us know there have been biopics and documentaries and all sorts of, she's become a pop culture figure. But tonight I thought we'd focus more on her legal work. As part of her inspiring life story was the lawyering that was shared the center of that. You know, she was confirmed by the Senate 96-3 in 1993, and I think just as remarkably, when we think about today's world and even several decades now of nominations since, she was really the last justice to lead a life of advocacy before coming to the bench. Most of the others follow a well-trod path that involves less of a paper trail, less statements, less positions, less championing of causes, really. So let's start there, maybe with her work with the ACLU Women's Rights Project and her beginnings in her life's work in gender equality. How did that begin?
Well, I don't know if we ever really know how we begin down our paths, because I don't know that it was obvious that Justice Ginsburg would become Justice Ginsburg even when she was beating everybody else in her class at Harvard and Columbia law schools. I don't know that she particularly saw herself in that light. Some people attribute it to her having gone to Sweden for a year. It's interesting to think that she actually had quite a long career, not a long career, but a decent career, a decade of being an academic. And she went to Sweden and she wrote a book about Swedish civil procedure. And, you know, I think in retrospect, at least, the story is that she saw a different and more egalitarian life in Sweden. And it changed her view of things, that she saw, she visited a Swedish judge, was 8 months pregnant. And that she was surprised because, you know, at that time, in the United States, that wouldn't have been possible. I wonder if she had just simply been able to get a job at a law firm after graduating, if she would have been a very successful partner in, I don't know, some area of law, insurance law, tax law. She would have been some type of civil litigator or appellate lawyer. And she actually ended up taking a job in academia, and at first at Rutgers rather than a top law school, partly because of discrimination against her because she was a woman. And then, of course, she found her life's passion.
So in these early cases that she brought, she I think brought 6 cases to the Supreme Court and won 4 of them. 1 was mooted, so only a pretty good record.
She really liked the mooted one.
Well, she was able to get back to it, right, by the jury issue. Her clients were men. Right?
Mostly. Her clients were mostly men. Often, that's how she revealed gender inequities in our laws, in our state and federal laws, by saying, well, why is it this man whose wife has died, who wants to now be the caretaker for their child, isn't eligible for these benefits, although a woman would be had her husband died? Why is that fair? So she would represent men who at that time were maybe, you know, certainly not radical, but for one reason or another, flouting gender norms. So many of her cases, she liked the idea of choosing men as plaintiffs because it highlighted the fact that sex discrimination harms everyone. And of course, she was arguing to a court that had no women members and had never had a women justice at the time. But the case that was mooted, Struck. Are we thinking about the same case, Struck versus Secretary of Defense?
Oh, well, so there was the one that she brought, that was another one, right? I think Edwards was the one I was thinking was arguing involving jury service, but Struck was one, you know, her first case, Frontiero, was argued the week before Roe v. Wade came down, and she was working on another gender discrimination case at the time. Struck, tell us about that.
Struck was an Air Force captain who had become pregnant while on service in Vietnam, and her religious beliefs precluded her from getting an abortion, which is what the military regulations at that time, Air Force regulations, basically said, you can have an abortion or you can be discharged. And she was quite dedicated to her job as a captain. And at the same time, she did not believe in having an abortion. So she represented a woman who fought to she put the baby up for adoption. And ultimately, the Air Force relented and did not discharge her, which is what mooted the case. But I think that Justice Ginsburg felt as if Struck's case would have placed the concept of pregnancy discrimination and choice before the court in a sort of better and less incendiary context than did Roe.
Mm-hmm. Let's come back to that issue once she's on the court as well. So that work towards gender equality continued and really culminated in the VMI case in 1996. How can you explain kind of the arc of she basically created current equal protection doctrine for gender discrimination. How did that work from the cases that she brought to finally being able to tie it up in a bow in some ways at the end with Virginia and say, here's the law? Okay,
so I guess what I don't know if is evident because she's become such a kind of public figure and it's a little bit detached from what she actually did. The justice accomplished a vast amount in her career as an attorney and as a judge and justice, but she was not a radical in any way. She was not a revolutionary. She studied and taught civil procedure, which I also study and teach, and my children make fun of me for doing that, because as they say, the Facebook group for civil procedure scholars who want to burn the whole system down is very small, right? She was working within the system and believed that the system was legitimate enough that she could do that. And so her approach in these gender cases was incremental. She was seeking modest holdings from the court each time. Even the scrutiny that she eventually won under the equal protection standard that the court adopted is not, it's not a black-white form of review by the court. Governments may sometimes still make distinctions based on gender. They simply have to have a good reason for doing it. And that distinction has to be, whatever the distinction is, has to be narrowly tailored to that good reason, which is to say, in her view, she was a believer in moderate change so that it was, no step was too big. Everything was fairly restrained. And there were ample opportunities for the co-equal branches of government to speak. And again, I don't think that Justice Ginsburg believed that Roe versus Wade had those advantages. And she at least thinks that that is one of the reasons why it has become such a flashpoint.
She was criticized from the left when she was nominated as not being sufficiently, being too incremental. Right? Despite this, we look in retrospect and see the masterful strategy that she had helped build up around establishing gender equality under the 14th Amendment. But it did not make her popular in all quarters. It was, there's similar, Thurgood Marshall's fight for racial equality followed a very similar path of incrementalism building up to a final sense of equality, right? That of course is continuing to be shaped. So we brought up abortion a few times. In the Virginia Military Institute case, it dealt with sex or gender discrimination, and she was one of those responsible for using the word gender, or I guess her assistant, right, reminded her that maybe you want to use gender instead of sex when you talk about discrimination under the 14th Amendment. But she never authored an opinion for the court addressing abortion or abortion rights.
She didn't, and I think in a way, Virginia Military Institute, right, where she wrote the opinion for the court saying that this all-male state military academy, which was so important to producing graduates who joined the upper ranks of the military, was unconstitutional in the way that it excluded women and allowed women to go to a kind of separate and allegedly, but definitely not actually equal version of the institute. That was really her main opinion as a justice, majority opinion as a justice on an issue related to women and gender. On the other hand, the reason it's hard for me to know why she wasn't writing more opinions in the area of reproductive rights. Partly it's complicated. Casey was a per curiam opinion, right? It's just right before her, so that there's not as much room for decision making. Also, she was never, until Justice Stevens stepped down, she was never the senior justice. So when the court gathers to decide their cases and they vote on cases in conference, the most senior justice who has 5 votes or more votes gets to assign the opinion. And frankly, that was not Justice Ginsburg. The court stayed static for so long that she remained a relatively junior justice for an incredibly long time. And that had an effect to some degree on which decisions she was assigned.
And in writing and in public throughout most of her career, I believe I think she continued to believe that she had the better case to establish rights of reproductive choice one way or the other, at least compared to on an equality basis, as opposed to the liberty or privacy basis that the court decided on, right? I mean, there was a point she commented how if you read Roe against Wade, it really is much more about the physician's rights rather than the woman's equal status in society, and she, I think, viewed it more through that lens.
I agree with that. I think that's her main philosophical viewpoint, right? Is that in the dignity of the equality of all persons. I think that, and again, I think some people feel that's not radical enough, that her feminism is not intersectional enough, and depending on your viewpoint, those things may be true, but she was quite consistent throughout her career, both as a litigator and.
Are there areas of law where she might have gone in a direction that might be surprising to the casual observer, or that might be appreciated?
Okay, well, surprising to the casual observer, I don't know. I don't always agree. As a procedure person, I don't always agree with her civil procedure opinions, but that's pretty wonky for a generalist audience, right? I don't agree with her decisions on general personal jurisdiction, for example, which really limit lawsuits often against corporations to states where those corporations are incorporated or have their principal place of business. And, frankly, I think that's really disadvantageous to people in a state like Montana that's far from Delaware, far from New York, where these companies are incorporated. I think it was a way of simplifying the law, and but it's a constitutional ruling, and I frankly think that it's quite harmful to people who live outside of these very few places where corporations tend to be concentrated. So, but that might be too clear.
Well, there's a Montana case this week at the court that was argued.
Correct. And I think, I probably won't agree with the court's decision in that case either.
We'll come back and see if we can get a couple hundred people to listen to us talk about about that jurisdictional case. Right?
Really? Why would nobody find that interesting?
I'll have our colleague and friend Craig. He'll do that one.
That'd be fine. What's actually remarkable about the justice is that she's wildly famous, and so many people mourned her passing, and she was an absolutely essential ingredient on Supreme Court, right? It's an ensemble cast, right? And she was at the center of it. And yet, many of her most famous opinions are dissents, right? So she's most famous in a way for her litigation history, for sort of what she brought to the court. And the fact that actually we could bring those things, we could openly talk about civil rights and human rights and then become a justice on the one hand, and her dissents, which actually many of which are fairly recent, on the other.
You say in terms of the ensemble, there were a lot of cases outside of, particularly in these more technical areas, but also in some of the more ideologically freighted areas, right, where she was not only a friend with Justice Scalia off the bench, but would associate with Justice Scalia or Justice Thomas in certain cases dealing with statutory interpretation. Right, there's a punitive damages line of cases. She was the only justice who thought that the Constitution was silent on the question of tort reform and punitive damages limits.
And again, I think she's quite respectful of state law, state courts, and state autonomy, and that was her decision in that case is rooted in that as well, which doesn't exactly accord with sort of the traditional views of what constitutes a liberal versus a conservative justice. I think those lines are actually much more blurry. Typically, the court has about 50% of its docket typically is unanimous, really, not anonymous, but unanimous, right? So there are many cases where the court is still just kind of resolving issues as to which there's a difference, where there needs to be an answer. And especially if it's statutory, Congress could always change its mind.
Right. And well, there is famously the Ledbetter case where she urged them to, and they did.
Yeah, one of the things I think I really admire about Justice Ginsburg is, even as over time, a real faith in the institution of the court, even though she was dissenting fairly frequently, and also faith in the coordinate branches of government. And in the Lilly Ledbetter case, Congress reaffirmed that faith by taking her up on her sort of urging to them to amend the law so that women could seek fair pay and not be blocked by the statute of limitations.
It's the respect both across Washington itself and then out to the states is something that she wasn't an imperialist in terms of trying to decide everything. She had a great deal of respect for colleagues in both on her bench as well as every other branch of government.
Yeah, actually, when I was preparing, I'm giving a few of these talks, and I went back and looked at her writing, and one of the things that really hit me was that she's written a remarkable number of tributes to other justices or judges or jurists who were either being honored for something or had passed away. Or historical figures who maybe did things that were very interested in the early part of our nation. She's got this sort of kind way of commemorating people that also is a celebration of the rule of law.
As we wrap up this segment, we'll turn to questions and would ask people both on Facebook or in the chat if you have particular questions about Justice Ginsburg, the person, the justice, the legal and other legacies. Go ahead and post those in the chat. You can send them to me directly. If you put them on Facebook, they'll come to us via the Mansfield team. So looking forward, what will the court miss the most without Justice Ginsburg? You've talked about the ensemble. What is the ingredient that will most be lacking going forward?
No, because it'll be a different mix of people. But I do think that her very sincere and deep form of collegiality was an important ingredient in the functioning of the court. Her belief that in the overwhelming sort of importance of the legitimacy of the institution. Her friendship with Justice Scalia is quite famous because they rode an elephant together, and there's a picture of it. But she was on good terms, as far as I can see, with everyone of the court. I know she was on excellent terms with Chief Justice Rehnquist, who was very kind to her when she had cancer and offered to give her a lighter caseload, which of course she did not take. But it's hard to know from the outside whether the court will maintain the level of warm collegiality that it has. It's difficult to know. I also think that Justice Ginsburg was a forthright defender of the concept of a living constitution, of the Constitution as a document with a growth mindset rather than a fixed mindset. And she spoke about that openly at her confirmation hearings. And I feel like that's not necessarily going to be a view that garners 5 votes in the upcoming future. And that's important for the country.
To think about Chief Justice Rehnquist, for example, when she was arguing before the court for gender equality, he was dissenting, right? He was against providing heightened scrutiny, as we'd say in con law, for gender classifications. And by the time she authored the Virginia case in 1996 and closed the loop there, he'd signed on. I mean, he concurred. He didn't buy everything, but he did a 180 in terms of where he ended up. And I think it's hard to see that as other than a product, not just of Justice Ginsburg's intellect, but of the way the court is able to work together to do better work, right?
Yeah, and I mean, in 2003, while I was there, Chief Justice Rehnquist wrote the majority opinion in Hibbs, in Laude versus Hibbs, which was a case. It was an interesting case. It was a male plaintiff arguing about eligibility under the Family Medical Leave Act, So it was a little bit of a Justice Ginsburg strategy to bring a male plaintiff rather than a female plaintiff before the court. And his opinion actually, I think it reads like something she could have written. So, you know, when he changed his views, he changed them. He also, however, was a very deep believer in stare decisis and in respecting precedent. And that's something else that I don't know that the court will adhere consistently going forward.
Yeah. There's a bit of a caretaking story behind that as well, I think, as Chief Justice Rehnquist had experienced maybe, you know, a relatively rare occasion in his life of being in a position of being the caretaker that Justice Ginsburg knew all too well throughout her life.
I think she was very good at bringing to light the pragmatic impact of the laws in a way that wasn't always obvious to the court because, you know, many of them had spent their lives in relatively rarefied circumstances, legally speaking.
Right. You know, well, just before we, as we turn to questions, and I think it's a segue of her her practicality, not an easy practicality, but her very sharp focused practicality, clear-eyed practicality. One area where she's known to fall short, and this is as good a time as any to acknowledge that our university is on the traditional lands of the Salish, Sanka, and Kalispel people who have had and continue to have a crucial presence here, is her Indian law decisions. And she wrote a couple of the most derogatory of sovereignty, I guess is the way to, in terms of a major decision involving upstate New York and the Oneida Nation, as well as a decision that has consequences still in Montana with respect to the civil jurisdiction. What do you have any insight into those cases? It's a famously difficult area of law, and both of us are way out on a limb without my colleagues, Professor Stark and Professor Mills here. But is that at all a reflection of her general approach to things, the Indian law cases, which have been quite criticized?
So I think it's difficult to make generalizations about the Indian law cases because tribal cases involve such a wide range of topics. But I would say that that's another area where I have disagreed with her. And I in particularly disagree with her decision in the sort of land cases. I was litigating a case coming from New York. We were representing the Cayuga. And again, these cases were arguing that basically the land had been stolen from the tribes in the late 1790s, early 1820s. And you can see that it's very difficult to bring a legal claim after so much time has passed. But nevertheless, the case where Justice Ginsburg basically eliminated land claims, at least in the Second Circuit, have been up to the Supreme Court. That was its third trip up to the Supreme Court. And I think third. If they were going to end that litigation, they should have ended it 15 years prior. So I felt like it was not only an incorrect decision on the merits, but also pretty disrespectful of reasonable reliance issues of all the parties. So I don't know if you can say, make generalizations about it, but I didn't agree with it. And I am also one of the people that believes that it would be good if we had a bit more geographic diversity among our justices.
In many, I guess it's been reported secondhand at least that the Oneida Nation case was one of her regrets, I guess, looking back. It's easy, of course, for someone who is less focused on the on the ground reality to take a very sharp formal view and just say, this is what the treaty says, we're going to do it, as in fact we've seen in more recent cases, in the Oklahoma case. But it did seem that a strange sort of equities were weighing in that line of cases, particularly given the delay. Yeah, there are some a couple of questions now coming up. This is a great question from a student. When the justice wrote her dissents, was she writing it, why did justices dissent? Was she writing it as an instruction to a future court, hoping they might adopt her reasoning, or was she writing it to the American people as a way to affect change, or something else?
That's a great question. And the answer is probably not consistent even with each individual justice. Some dissents, sort of 5-4 and 5-4 cases where there are 4 justices, you write the dissent hoping that eventually it might become the majority. I think sometimes Justice Ginsburg's dissents were aimed at maybe more narrowly at just highlighting the methodological weaknesses of decisions by saying, really, we're not going to take into account the history of racial segregation when we look at this affirmative action case. She tended to want to pay attention to the historical record and put things into context. And I think that might be a different reason than trying to get 5 votes. So she also believed actually that you shouldn't always write separately. You shouldn't always concur. You shouldn't always write a dissent. You don't always have to make your views known. So to some extent, even her dissents, which were now the most famous body of her justice, judicial decisions in the Supreme Court, it's a fairly restrained group, although less restrained over time, over the past decade.
And one area where she was, she did write some concurrences and a quite sharp dissent in one of the more recent abortion cases, but in the gay rights cases, as we might call them as a whole at the time, which Justice Kennedy authored all of them, she never wrote separately. She had a very clear vision of equality, a vision of gender equality, which we can assume, and they're all indications that she thought would extend to sexual orientation and gender identity. And yet she didn't write at all in those. Thoughts on that? Is it, again, just part of a junior justice, or?
She was still a junior justice, but these cases happened well into her tenure. And I have no special inside information, but I guess just as an observer, I feel like Justice Kennedy's opinions in many of these cases read quite differently than many other judicial opinions. I don't know if I can use the word lyrical. They're more lyrical, which can make them quite frustrating if you actually want to find out what standard, right? Tell that
to my students, yes.
Right, sorry, right? Yeah, it's like, I don't know what the standard is, but I'm going to test you on it on Thursday. And I think a kind of, even if very eloquent, dry concurrence would actually be a little bit out of step with that holding. And it seems like the court will have other opportunities to refine that. But I can see where you're coming from. I also think she may feel like the court should speak as much as it can with one voice when it's making a big decision like that. And that voice was going to be the voice of the 5th vote, and that was Justice Kennedy. Although I don't really know if you can call Justice Kennedy the 5th vote in these contexts, because he did seem to have his own views and maybe be a leader. Maybe he was bringing others along. I don't know.
Yeah. Well, a little bit turning to more broadly, her role and legacy with respect to the court as an institution. A student asks, is there still a path to the bench through legal advocacy like Justice Ginsburg and Justice Marshall and others? Leading the NAACP or ACLU's litigation strategy through a decade, is that a good way to end up with a seat on the Supreme Court anymore?
It's hard to say never. I'm a bit worried that we're not looking for those stories anymore. We're afraid of people having expressed their views. And therefore you get somebody who just always got an A and always did the kind of next step thing without really ever going out on a limb. But, with luck, the country will go on for many other hundreds of years, and we could swing back that way. But it's been a while. Justice Sotomayor has an amazing and inspiring personal story. And her autobiography, her memoir, is truly remarkable. And I don't read justices' memoirs for fun. Her memoir is really beautiful. But as an actual attorney, right, she was a prosecutor for a good part of her job. She was not particularly radical. And then she was a judge on the Second Circuit for 10 years, during which time she was not a particularly, I guess how you would say it, activist judge. So she's now the most progressive justice on the court and often a lone dissenter in the current context. But she doesn't have an advocacy background like the justices. I don't know if that's possible anymore. Even for lower court judges, I don't know if it's possible anymore. I worry that we're a little bit too focused on getting A's but not making waves, and that's not necessarily conducive to innovative thinking, to having a robust conversation, right? Justice Ginsburg's comments at oral argument in the Reading case were quite famous. I don't know if you remember Reading. It's Reading versus Stafford Unified School District, where the case involved the strip searching of a 13-year-old. My daughter just turned 13, so I find this case like only as truly horrifying as it is just now, when I imagine my daughter being strip searched at school because somebody had said that she'd been handing out prescription strength Advil. And the justices on the bench famously didn't seem to think there was anything of it. And Justice Ginsburg was like, seriously? You did that when you were in middle school, when you were 13? That was normal? Think of what that would mean to a girl who's in the 8th grade or the 9th grade. She's a little bit of this voice of kind of willing to say things. And the court actually ultimately agreed with her and ruled in favor of this girl. But I don't know, gathering candidates who have those kinds of voices, who are willing to speak out quite in that same way. I don't know.
Another question that notes that at the same time that Justice Ginsburg, as a lawyer, was bringing these cases establishing gender equality under the 14th Amendment's Equal Protection Clause, the Equal Rights Amendment was out on the streets. Any thoughts on how she viewed the relationship of her work in court to the Equal Rights Amendment?
I actually don't know her view, except for I think she believed that the Equal Rights Amendment, at least for some time, would eventually pass. I think what she would say, and again, she is not a radical, is that the Supreme Court is not, and probably should not be, dramatically out ahead of public opinion. And the Equal Rights Act, a growing consensus, it didn't grow quite fast enough, was not enough of a consensus, right, within the time period allocated. But that what her cases were basically, she's advancing recognition of gender equality at a time when the country was, for many different reasons, ready to hear that message, and the court was ready to do it. I think what she didn't like about Roe, and in general about the court, she didn't like the concept of the court getting out ahead of public opinion. So the court's same-sex marriage cases, Obergefell, by the time the court decided Obergefell, it really represented a broad consensus of the American public. Certainly not everybody agreed with it, but it was a quite mainstream view to hold.
There's a question about Citizens United, which was not a case that she wrote in. She was in the dissent on it, but maybe more generally, she did write some notable majority opinions, notable dissents in election law cases. Famously dissenting when the Supreme Court struck down part of the Voting Rights Act, she said, throwing out the Voting Rights Act when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet.
Shelby County is a pretty hard case to think about now as we're going to vote, when there's sort of open voter suppression stories in the newspaper all the time.
She had a complicated relationship with kind of on the ground reality, because of course she also wrote a couple of opinions that actually protected what we would call dark money, at least in low levels. She was very practical. Again, she didn't draw bright lines. in the way that Justice Scalia would be. Said there's no problem at all with requiring disclosure. She'd say, I think in the McIntyre case, in for a calf is not always in for a cow with respect to campaign finance disclosure.
Again, that's what I find interesting is that it's hard for me to really understand her mainstream popular legacy, and to what extent it's tethered to her cases, or to what extent it's a reflection of just her as a person who defied all the odds and did it in a quiet way. Right? She's not a tall person. She's not a loud person. She just sort of embodies this very restrained, massive power. That's again, a little bit, although not totally, divorced from her actual decisions as a justice. As actually wonderful as they were.
There's a couple of other questions here. One is from a student. Are there any non-legal reading materials that the justice would engage in, or was she all business, just reading the briefs day in, day out, and the reports, or do you know what she was reading, or did she ever recommend anything to you?
No, I mean, she did take us to the opera once. And I have to say, I just feel like the opera was too much for me. So, and I had heard that she occasionally liked to watch, like, I don't know, maybe rom-com movies. But it's not that I think she didn't do things other than law. I think she did, but I wonder how much of it was reading. So, and I don't know who asked the question, but I also found when I was clerking, sometimes even now, if I'm really involved in writing a paper, I find it hard to read things because I just, after like 2 paragraphs, I'm like, oh, I know what's going to happen. The holding of this case is obvious. But I think it may just be that she only spent a certain number of hours a day reading text. So she never actually did recommend a book to me. I don't think I ever talked to her about books, but I'm not saying she doesn't. I didn't know. Whereas she, for example, she also had tickets to the symphony. One day she sent us, the clerks, to go see. She couldn't go to the dress rehearsal for a symphony, so she sent us to go. She did a lot. She had a lot of cultural interests. When she went to New York to give talks, she would always kind of stop in some art gallery. But I don't know how much it was reading, because I think she had quite a lot to read. She, and she was such a night owl, so she would stay up really late reading her briefs. I don't know. Somebody asked if she saw Hamilton. I hope she saw Hamilton, but I do not know. It did come to the Kennedy Center, which makes me think she might have seen it because she lived at the Watergate right next to the Kennedy Center.
Okay. Short commute to culture. A question from students about oral argument and how she approached oral argument. I think there's always that question, does it even make a difference? What was she like in oral argument?
She's fantastic in oral argument. She is amazing at oral argument. She tends to ask excellent questions. She tends to ask clear questions that are really getting to the heart of her case, or what her decision will be. She's very thorough with the record. And that just often is a really important ingredient in how the court will resolve a case. Studies have been done saying that the women justices are interrupted more than the male justices, and I'm sure that's true. But I also am convinced that the justice would get her questions out. One of the things that I had to do when I was writing a memo for the justice for a case that would be heard, I had to write 3 recommended questions for her to ask. And I always took a lot of time thinking, like, okay, what would my 3 questions be? And actually, one of my favorite parts of clerking would be if the justice asked one of my questions and the person kind of collapsed. I know that's terrible to say.
Very scary as a lawyer.
Once I still remember somebody submitted an additional brief after the argument, just in response to the one question. And it's because I think she really cared, maybe because she'd been a litigator for a while. She was really sensitive to what had happened in the courts below. She was very respectful of what had happened. And it just made for great questioning. Plus, no ums, no ers, no hesitations. But Justice Scalia could often be very funny on the bench, and Justice Ginsburg wasn't like that. She was really businesslike.
Yes, because only a law professor would read all the transcripts at every given term of the arguments and count the number of laughter indications in the transcript, right? And they'd rank the justices by how many laughs they got.
I definitely would be first.
Yeah, I think
Justice
so.
Breyer, close second. That's where I am.
Yeah. But also true that, the interruptions. Although it was really, as quiet as she was, there is a sense about the courtroom that everything got very quiet when she was asking a question, a kind of hush felt, because I think the power of how incisive those questions were.
I listened to a transcript of her arguing as an attorney. It was the case, I forget what case it was. It was the same day in which the case decided Craig versus Boren, which for those of you who are lawyers or law students was the case about whether or not 18-year-old boys like 18-year-old girls could buy 3.2% beer, right? It was the near beer case. And the justice had been helping the woman in the Craig versus Boren case who owned this tavern, the Hoot and Holler. But I think the male attorney who had had the case originally maybe didn't want to give it up. So he had done the argument before her, the 10 o'clock argument. And I don't know if he had done a very good job. I don't know that. But she argued the next case. And during the next case, she looped back and argued Craig versus Boren as well. And if you listen to the transcript, the case opens. She's standing up there and no one says anything for about, I don't know, 20 or 30 seconds. And then the Chief Justice said something, like just was like, Counselor, Ms. Ginsburg, and she was just gathering her thoughts. And I was like, wow, that is just really a power move. And then when she starts, again, she has no hesitation and she just speaks with such clarity, which is, again, a little bit terrifying if you're working for her.
We have a few more minutes left for any other questions. So a question about in terms of her work-life balance. It sounds like a night owl, although she enjoyed her opera and symphony. Other lessons you learned about lawyering and entering the workplace? I mean, here it says right at the beginning of your legal career that you learned from her.
I would say she was very respectful of the attorneys before her, even the attorneys who were not doing a great job. Arguing before the court has become increasingly specialized, as you know, Anthony, and so it's harder and harder for regular attorneys who aren't used to that practice to either take their cases all the way to the Supreme Court or to fit into that now, I think, more than what it used to be, very rarefied culture. And I think she really valued all attorneys. She really respected the people who came before the court and always spoke about her job and her profession that way. And I think that's important, especially entering a profession where sometimes people casually make lawyer jokes. I think she thought about her own work product in a very serious way and was incredibly critical of herself, I think, if she didn't feel like it was what she wanted, but she didn't treat others that way. She was much more understanding, and I think that's a nice way to be. I feel like all the best lawyers are kind of quiet, which is why I'm not one of the best lawyers. I have to still work on that.
Well,
she did once buzz me into her office because I thought, oh my God, what's happened? And I come into her office and I think like I've made some major mistake. And she said, and I don't even remember which way it is anymore. She said, like, in Supreme Court style, there's, I think, one space after a semicolon, not two spaces. I was like, okay, anything else? So in her own writing, and I was working on her own writing, that was the level of expectation.
Well, that might be both her approach generally to work and her balance and her great attention to detail might be a good place to end. Closing thoughts, Liz, on this remarkable American life?
No, just that she is one example of a remarkable American life. Actually, I think the same thing about Antonin Scalia. I think he was also a real American voice, and I hope that going forward, the court can retain the legitimacy and the intellectual rigor that it had during the time of Justice Ginsburg. Yeah.
Well, that'll be a discussion we'll save for next time. Well, Liz, thank you so much.
Sorry.
Yeah, no, managed to hold off the entire time.
Yeah,
So
the teenagers.
I haven't had any dance parties with the kids upstairs yet either. So
really nice to be here. Thank you very much for having me. I loved living in Montana, and I visited Missoula earlier this year and had a great time. So I'm really glad to, even though I can't see all of you, I'm glad to have had this opportunity.
oh, thank you, Liz. And yes, we will have you back IRL, as the kids say, just as soon as we can.
I hope we can be IRL soon.
Yes, yes. Well, thank you so much. And thanks to the Mansfield Center. I'll turn it back to Dina as we say goodnight.
Well, thank you so much, Liz and Anthony, for this fascinating discussion. It's great to have an inside perspective on the life of Justice Ruth Bader Ginsburg and have your unique perspective on constitutional law and the impacts on our country. So again, thank you all for being part of this first Mansfield Dialogue for the fall. We're honored to partner with this dialogue, as Anthony said, with the community of excellence here at the University of Montana on justice, policy, and public affairs. Honored to partner with the Blewett School of Law here at the University of Montana. And these dialogues are designed to bring community together to discuss critical issues in international engagement and public affairs. We hope that you will join us next week on October 14th, where we will have Professor Rob Saldin speak on the Never Trump Revolt and the Future of American Democracy, a very timely topic. We also have a couple of exciting announcements next week in terms of a new endowed scholarship in ethics and public affairs, and also announcing our new director of ethics and public affairs. So thank you again for joining us tonight, and we hope to see you next week. Thank you.
Thank you.